Well, so we ended with the discussion of the question number 43. However, our this explanation or discussion has not happened. So let us see the explanation section. But before that, let us recap once again. So 43 was about the maternity leaves. Okay. So first statement is that the maternity leave is a constitutional right even for the birth of the third child. Okay. So then Maternity Benefit Act allows 26 weeks of paid leave for every child. There is no mandatory rest period for the women after her marriage. So which of the following are incorrect? Okay, so 2 and 3. So 1 is basically correct. Okay, so let us see the explanation part. Now, recently, the Supreme Court has affirmed that maternity leave is available even for the birth of a third child. Okay, third child. The court observed that the leave is not just about fairness of or social justice, but also a constitutional guarantee. The Supreme Court judgment in K. Umadevi versus Government of Tamil Nadu elevates maternity leave to a constitutional entitlement under Article 21. It reaffirms that the right to life includes the right to reproductive health, bodily autonomy, and maternity dignity. By harmonizing service rules with fundamental rights and international standards, the court has ensured that rigid policy frameworks do not defeat constitutional values. So, statement one is correct. Now, maternity leave is a paid leave provided to women who are expecting or pregnant, allowing them to utilize it before and after the delivery of their child. Oh, sorry, just a minute. Yes, all employers or organizations in India. So all employers or organizations in India are required to provide maternity leave to pregnant women. It is essential to ensure the overall well-being of both newborn child and the mother. In 2017, the Maternity Benefit Act 1961 was amended to include various aspects such as an increase in the maternity leave period, the option to work from the option to work from home, and the maternity leave for mothers adopting a child. Maternity leave for mothers adopting a child. Okay. The Act provided for a maternity leave of 12 weeks. This duration was increased in an amendment to Act in 2017, and all women are eligible to take a 26-week maternity leave. They can take maternity leave from 8 weeks before the delivery date and take the remaining 18 weeks after the delivery. When a woman already has two children, the maternity leave is only for 12 weeks for the third child. Therefore, the Maternity Benefit Act allows 26 weeks of paid leave for the first two children and uh, 12 weeks for the subsequent children. So, statement 2 is incorrect. In case of miscarriage or medical termination of pregnancy, a woman shall be entitled to leave with wages at the rate of maternity benefit for a period of 6 weeks immediately following the day of her miscarriage. Therefore, there are 6 week rest periods for women after her miscarriage. So, statement 3 is not correct. Now, let us look at the Maternity Benefit Act 1961. So, the Act regulates the employment of women in certain establishment for a certain period before and after childbirth and provides for maternity and other benefits. The Act applies mines, factories, circuses, industry, plantations, and shops. An establishment employing 10 or more persons, except employees covered under the Employment State Insurance Act 1968. It can be extended to other establishments by the state governments. There is a no wage limit for coverage under the Act. Now, employment of or work by women is prohibited. No employer shall knowingly employ a woman in any establishment during the 6 weeks immediately following the day of her delivery or her miscarriage. During the period of 1 month immediately preceding the period of 6 weeks before the date of her expected delivery. During a certain period, a pregnant woman cannot be forced by her employer to do strenuous or prolonged standing work or any task that might harm her pregnancy, fetal development, or overall health. Right to payment of maternity benefit. Every woman is entitled to get maternity benefits, and employers must pay them at the average daily wage for the period of her actual absence immediately preceding and including the day of her delivery. A woman who legally adopts a child below the age of 3 months or a commissioning mother shall be entitled to maternity benefit for a period of 12 weeks from the date the child is handed over to the adopting mother or the commissioning mother. Maternity benefit in case of the death of women. If a woman entitled to maternity benefit dies before receiving the benefit, the employer must pay the benefit to the person nominated by the women. If there is a no nominee, the benefit should be paid to her legal representative. Uh, SACE facility. Every establishment with 50 or more employees must provide a case facility, either separately or alongside other common facilities. The employer must permit the women to uh, says each day, which also includes her designated rest intervals. Additionally, every establishment must inform women in writing and electronically about all the benefits available under this act at the time of their initial appointment. Dismissal during absence or pregnancy. When a woman is on maternity leave in accordance with this act, the employer cannot discharge, dismiss, or give notice of discharge or dismissal. The employer also cannot change any of her uh, service service conditions. On the other hand, if a woman is discharged or dismissed during her pregnancy, when she would have been eligible for maternity benefits or medical bonuses, she cannot be deprived of these benefits due to discharge of or dismissal. However, suppose the dismissal is due to severe misconduct as defined by the regulations. In that case, employer can withhold the maternity benefits or medical bonuses by or both by informing the woman in writing. Now, question number 44. With reference to fundamental rights of freedom of speech and expression, consider the following statements. It is only available against the state and not against private individuals. Yes, this is correct. And just a second, it is only available against the state and not against private individuals. It is only available to the citizens. Yes, the state can impose reasonable restriction on this right if it affects friendly relation with the foreign nation. Yeah, that is also correct. And now let us see the explanation. So B is the correct 2 and 3. Okay. So explanation. So Article 19 guarantees to all citizens six rights under right to freedom. These are right to freedom of speech and expression, right to assemble peaceably and without arms, right to form associations, unions, or cooperative societies, right to move freely throughout the territory of India, right to reside and settle in any part of the territory of India, right to practice any profession or to carry on any occupation, trade, or business. The Supreme Court, the Supreme Court in the Kishore versus Kausal in the Kausal Kishore versus State of Uttar Pradesh case held that Articles 19 and 21 can be enforced not only against the state but also against private individuals. This gives these rights a horizontal application, allowing them to regulate relationship between private parties. The judgment marks a major expansion of constitutional law, extending protections of free speech and personal liberty even in private sphere. While the judgment strengthens the citizen to citizen enforcement of Article 19, it still does not extend it to foreigners or corporations. Therefore, freedom of speech and expression is available against a state and also private individuals, and the right is available only for citizens. So, statement one is not correct, and statement two is correct. Now, freedom of speech and expression implies that every citizen has the right to express their views, opinions, beliefs, and convictions freely by a word of mouth, writing, printing, picturing, or any other manner. The state can impose reasonable restrictions on the exercise of the freedom of speech and expression on the grounds of sovereignty and integrity of India, sovereignty and integrity of India, security of the state, friendly relations with foreign states, and then you have public order, decency or morality, contempt of court, defamation, incitement to an offense. Now, additional information. Let us look at that. So, freedom of assembly. About every citizen has the right to assemble peaceably and without arms. It includes the right to hold public meetings, demonstration, and take out processions. This freedom can be exercised only on public land, and the assembly must be peaceful and unarmed. This provision does not protect violent, disorderly, or righteous assemblies, or those that cause a breach of public peace, or those that involve the use of arms. This right does not include the right to strike. Not include the right to strike. The state can impose reasonable restrictions on the exercise of the right of assembly on two grounds, namely sovereignty and integrity of India, public order, including what? Sorry, just a second. Public order, including the maintenance of traffic in area concerned. Section 100 Section 144 of the Criminal Procedure Code, now under Section 163 of the BNSS. A magistrate can restrain an assembly meeting or procession if there is a risk of obstruction, annoyance, or danger to human life, health, or safety, or a disturbance of public tranquility, or a riot, or any affray. Under Section 141 of the Indian Penal Code, Section 181 of BNS, an assembly of five or more persons becomes unlawful if the object is to resist the execution of any legal or any legal process or law, to forcibly occupy the property of some person, to commit any mischief or criminal trespass, to force a person to do an illegal act, and to threaten the government or its official with the exercise of lawful powers. Now, question number 45. Consider the following statements regarding socialist and secular in the Indian Constitution. Only after 42nd Amendment did the socialist content become present in the Constitution. Now, we have to trace out which of the following are not correct. Okay, so only after the 42nd Amendment did socialist content, they are saying, become present in the Constitution. No, that is not the thing. Though the word socialist was inserted only after 42nd Amendment Act into the Constitution, that is particularly in the Parliament. However, the as far as the socialist content is concerned, it was there in the fundamental rights. Okay, right to practice religion of their one's choice. Okay, so that is the not sorry, that is not the socialist. You have socialist content in the DPSPS, directive principles of the state policy. Okay, so this is wrong. Now, only the country of India has both socialist and secular principle in its constitution. No, that is not true. So this is wrong. So C is the correct answer. Let us see the explanation. The word socialist, now the word socialist, secular, and integrity were incorporated into the Constitution through 42nd Amendment Act of 1976. Even before the term socialist was added by the 42nd Amendment in the 1976, the Constitution had a socialist content in the form of certain directive principles of state policy (DPSP) The Indian brand of socialism is democratic socialism, and not communist socialism, also known as state socialism, which involves the nationalization of all means of production and distribution and the abolition of private property. The democratic socialism, on the other hand, holds faith in mixed economy, where both public and private sector coexist side by side. As the Supreme Court says, democratic socialism aims to end poverty, ignorance, disease, inequality of opportunity. Indian socialism is a blend of Marxism and Gandhism, leaning heavily towards Gandhian socialism. Thus, even prior to the 42nd Amendment Act, the concept of socialism was already reflected in the directive principle of state policy. So, statement one is not correct. Now, several countries apart from India explicitly enshrine socialist or secular principle within their constitution. Some of them are Nepal, Bangladesh, Tanzania, etc. Thus, India is not the only country that has both socialist and secular principles in its constitution. So, statement two is also incorrect. Now, next question: the distinction between the commercial and the political functions of the East India Company was made. So, distinction between the commercial and the political functions of the East India Company was made by which of the following act? So it was made through Pitt's India Act 1784. Okay, so bifurcation of the commercial and political functions of the East India Company was done by Pitt's India Act 1784. Let us explore this. So the Pitt's India Act of 1784 was a landmark law that brought the East India Company's rule in India under the direct oversight of the British government. It made a clear distinction between the company's commercial and political functions. The Court of Directors continue to manage commercial affairs. Okay, so Court of Directors continue to manage commercial affairs, continue to manage commercial affairs. A new board of control was set up to manage political affairs. A new board of control was set up. A new board of control was set up to manage political affairs. A new board of control was set up to manage political affairs, thereby creating a system of dual government. The board of control was empowered to supervise direct civil, military, and revenue matters of all company territories in India. For the first time, the company's territories were officially termed as British possessions in India. The act marked the beginning of the Supreme British government control over the company's administration in India. So option B is correct. Now the company rule 1773 to 1853, Regulating Act of 1773. It is the first step by the British Parliament to regulate the East India Company's affairs in India. So it was basically the first step by the British Parliament to regulate the East India Company's affairs in India. It acknowledged for the first time the political and administrative functions of the company. It laid the foundation of certain administration in India. It made the Governor of Bengal, the Governor General of Bengal, assisted by a four-member executive council. It made the governors of Bombay and Madras subordinate to the Governor General of Bengal. It established the Supreme Court at Calcutta 1774 with a Chief Justice and three judges. Now, it prohibited company servants from engaging in private trade or accepting gifts and bribes. It extended the British Parliament's control by requiring the company's court of directors to report revenue, civil, and military affairs in India. Now, Charter Act of 1813, it abolished the trade monopoly of the company in India. That is, Indian trade was thrown open to all British members. However, it continued the monopoly of the company over trade in tea and trade with China. It asserted the sovereignty of the British Crown over the company's territories in India. It was owed to the Christian missionaries to come to India for the purpose of enlightening the people. It provided for the spread of Western education among the inhabitants of the British territories in India. It authorized the local governments in India to impose taxes on persons. They could also punish the people for not paying taxes. Government of India Act 1858. It was passed after the revolt of 1857. It abolished the East India Company and transfers its power, territories, and revenues to British Crown. It established the Office of Secretary of State for India in London, assisted by 15-member Council of India. The Governor General of India was now called the Viceroy of India, representing the Crown. First Viceroy was Lord Canning, signified the beginning of the direct rule of the British Crown in India. Now, question number 47. Consider the following statements. How many of the above aspects are dealt with the Uniform Civil Code? So, only four are the correct answer. Now, let us see which are those. So, many divorce, inheritance, property dispute, reservation, succession. So, reservation, I think it is not part of UCC. Anyway, let us see. Article 44 of the Constitution, Indian Constitution provides for a uniform civil code for all citizens. The Indian Constitution, in its directive principle, lays down that the states shall endeavor to provide a uniform civil code for its citizens. Since directive principles are non-justice, civil courts cannot enforce UCC implementation. Uniform Civil Code (UCC) is a legal framework which provides uniform person laws across the country. It is a set of uniform laws that deals with various aspects, including inheritance, marriage, adoption, succession, divorce, maintenance, and property disputes applicable to all citizens irrespective of their religion, community, race, sex, and caste. It does not include the reservation. So option C is correct. The Uttarakhand government passed the Uniform Civil Code of Uttarakhand Act 2024 and the Uniform Civil Code Rules of Uttarakhand 2025, making it the first state in India to implement and enforce the UCC applicable to all residents of the state. Goa follows Uniform Civil Code for common family laws in the form of Portuguese Civil Code. Now, next question number 48. Under Article 19 to 19 Clause 2 of the Constitution, the freedom of speech and expression is not absolute. Restrictions can be imposed on which of the following grounds? So, sovereignty and integrity of India, yes, this is correct. Security of the state, yes, this is also correct. Friendly relation with the foreign state, yes, this is also correct. Public order, decency, and morality, yes. Contempt of court, yes. Defamation, yes, this is also correct. Incitement to an offense, yes, this is also correct. So all of them are correct. Now let us see the explanation. So freedom of speech and expression, Article 19(1)(a) grants citizens the right to freely express their thoughts. Just a minute. Thoughts, opinions, and ideas. This includes the freedom to express oneself through speech, writing, printing, visual representation, or any other means. But this right is not absolute. The state can impose reasonable restriction on the exercise of freedom of speech and expression on the grounds of sovereignty and integrity of India, security of the state, friendly relations with foreign states, then public order, decency or morality, contempt of court, defamation, incitement to an offense. The first set of grounds, namely the sovereignty and integrity of India, the security of the state, friendly relations with foreign state, and public order, are all grounds referable to national interest, whereas the second set of grounds, namely decency or morality, contempt of court, defamation, and incitement to an offense, are all concerned with the interests of society. All civil statements are reasonable restrictions that the state can impose on the exercise of freedom of speech and expression under Article 19(2) of the Constitution. Now, right to freedom. So, Article 19 in the Constitution of India protects certain rights. All citizens shall have the right to freedom of speech and expression, to assemble peaceably and without arms, to form associations or unions or cooperative societies, to move freely throughout the territory of India, to reside and settle in any part of the territory of India, and to practice any profession or to carry on any occupation, trade or business. Okay. Now, freedom of speech and expression. The Supreme Court held that the freedom of speech and expression includes the following: right to propagate one's views, freedom of circulation, freedom of the press, freedom of commercial advertisements, a right against tapping of electronic conversation, right to telecast, that is, the government has no monopoly on electronic media, right against the band called by a political party or organization, right to know about the government activities, freedom of silence, a right against the imposition of pre-censorship on a newspaper, a right to demonstration or picketing but not right to strike, right to fly the national flag, a right of voters to know the antecedents of candidates contesting elections, right to choose the medium of instruction at the stage of primary school, right to express gender identity, right to reply, right to answer the criticism, right to post information videos on the internet or social media, right of filmmakers to exhibit their films, right to access the internet, right to access to information via the internet. Okay, so this all are the part of the freedom of speech and expression. Okay, with reference to next question, with reference to the preventive defense, and consider the following statement: an enemy alien can be retained in the custody without informing them on the grounds of arrest. No, this is wrong. Are correct? Okay, correct. They're asking. So an enemy line can be detained in custody without informing them grounds for arrest. Yeah, this is correct. The power of preventive detention is an exception to Article 21. Yes, correct. Both Parliament and state legislatures have the power to enact a law for preventive detention. Yeah, that is also correct. So all of them are correct. Now let us see the explanation part. So basically, Article 22 grants protection to persons who are arrested or detained. Detention is of two types, namely punitive and preventive. So, punitive detention is to punish a person for an offense committed by him or her after trial and conviction in court. Whereas preventive detention, on the other hand, means detention of a person without trial and conviction by court. By Article 22, protection against arrest and detention in certain cases, no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest. No, nor shall he be denied the right to consult to be defended by a legal practitioner of his choice. But the protection shall not apply to any person who, for the time being, is an enemy alien to any person who is arrested or detained under any law providing for preventive detention. So statement 1 is correct. Now, the provision for preventive detention is an extraordinary power in the hands of a state that must be used sparingly. It curtails the liberty of an individual in anticipation of the commission of further offences, and therefore must not be used in ordinary course of nature. Preventive detention is recognized in the Constitution under Article 22, Clause 3, Subclause B. However, Supreme Court has emphasized in Rekha versus State of Tamil Nadu that power of preventive detention is an exception to the right to personal liberty under Article 21 and therefore must be applied as such as an exception to the main rule and only in rare cases. The Constitution has divided the legislative power with regard to preventive detention between the Parliament and the state legislature. The Parliament has exclusive authority to make a law of preventive detention for reasons connected with defence, foreign affairs, and security of India. Both the Parliament and state legislature can concurrently make a law of preventive detention for reasons connected with the security of a state, maintenance of public order, and the maintenance of supplies and services essential to the community. Hence, statement 3 is also correct. About additional information. So, Article 22 has two parts. First part deals with the cases of ordinary law, and the second part deals with the cases of preventive detention law. First part of Article 22 confers following rights on a person who is arrested or detained under an ordinary right to be informed of the grounds of arrest, right to consult and be defended by a legal practitioner, right to be produced before a magistrate within 24 hours, excluding the journey time, a right to be released after 24 hours unless the magistrate authorizes further detention. These safeguards are not available to an enemy alien or a person arrested or detained under the preventive detention law. The Supreme Court also ruled that the arrest and detention in the first part of Article 22 do not cover arrest under the orders of a court, civil arrest on failure to pay the income tax, and deportation of an alien. They apply only to an act of a criminal or quasi-criminal nature or some activity prejudicial to public interest. Now, preventive detention. The second, the second part of Article 22 grants protection to persons who are arrested or detained under preventive detention law. This protection is available to both citizens and aliens and includes the following. The detention of a person cannot exceed 3 months unless an advisory board reports sufficient cause for extended detention. The board is to consist of judges of High Court of a High Court. The grounds of detention should be communicated to detainee. However, the facts considered to be against the public interest need not be disclosed. The detainee should be afforded an opportunity to make representation against the detention order. Next question, which is question number 50. Consider the following pairs. Article Consider the following pairs. Let us see how much we have discussed. Okay, so I think we have started here. Okay, 44. Okay, so far just let us discuss 5 more questions. So question number 50. Consider the following pairs. Article in the Constitution of India and their description they have given. So Article 31. So I don't remember all of them. Okay, I just remember Article 31, 33. Sorry. So it is about the restriction of rights conferred by this part while martial law is in force to any area. No, this is not. Forces itself. So this is the. So this is the. This is given in Article 33. Hence, this is wrong. So only 4 could not be the correct answer. Okay. Let us see the. So Article 31 of the Indian Constitution was repealed and replaced by 44th Constitution Amendment Act in 1978. The original Article 31, which deals with the right to property, was one of the 7 fundamental rights under Part 3 of the Constitution, but it was repealed and replaced by Article 300A. Article 300A states that no person shall be deprived of his or her property except by authority of law. Thus, the right to property remains a legal right or constitutional right. Although it is no longer considered a fundamental right, it is not a part of the basic structure of the Constitution. Article 33 states that the Parliament can make laws to limit or even take away certain fundamental rights of people serving in the armed forces, army, navy, air forces, forces maintaining public order like police, paramilitary forces, intelligence and counter-intelligence organization, telecommunication staff connected to the above forces organization, armed forces, intelligence to ensure the proper discharge of their duties and maintenance of discipline among them. Article 34 in the Constitution of India provides restriction on the fundamental rights, while martial law is in force in any area within the country of India. It empowers the Parliament to indemnify any person in the service of the Union or a state or any other person in respect of any act done by them in connection with the maintenance or restoration of order in any area within the territory of India where martial law was in force. The Parliament can also validate any sentence, passed, punishment inflicted by done in the martial law in such an area. So it is correct. Now Article 35. So Article 35 lays down that the power to make laws to give effect to certain specified fundamental rights shall vest only in the Parliament and not in the state legislature. This provision ensures that there is a uniformity throughout India with regard to the nature of the fundamental rights and the punishment for their infringement. The Parliament shall have the power to make laws with respect to Article 16, 32, 33, and to make laws for prescribing punishment for acts declared to be offenses under the fundamental rights such as Article 17 and 23. Now next question, consider the following with respect to the reservation in promotion for government servants. So Article 16.4 of the Indian Constitution permits the state to provide reservation in promotion for depressed classes who are not adequately represented. This is correct. It is neither a statutory right nor a fundamental right. Yes, that is also correct. So C is the correct answer. So the Supreme Court recently clarified that the government servants in India cannot claim promotion as a matter of right because the Constitution does not prescribe fixed criteria for filling promotion posts. It is up to the legislature or executive to decide the method of filling such vacancies based on the nature of the job and the functions expected from the candidate. Article 16.4a of the Constitution, inserted by 77 Amendment Act 1995, allows the state make a special provision for the reservation in the promotion of for the scheduled caste and scheduled tribes. Saying that the groups of underrepresented in the government services are given opportunities for career advancement, including promotion with consequential seniority. In short, while promotion are not an automatic right for all employees, the Constitution provides for affirmative action for SCs to promote equity in higher equality in higher level government positions. So statement 1 is correct. In case of Mukesh Kumar versus State of Uttarakhand, in accordance with Article 64A of the Constitution, the Supreme Court had decided that there is no fundamental right to have a reservation appointments and promotion in public services. The Supreme Court stated that the Article 64 is enabling and the states may or may not make a reservation. So these all things we have. So we'll stop here. We'll not discuss much things now. Okay. So we'll discuss from 52 question of from 52 in the next chapter. Okay. So thank you very much.